Good morning, everybody. Thank you all for coming along this morning. We do have a couple of minutes until we officially start, but we're going to get some of the sort of preliminaries out of the way before we do. So, Ben, I think it's down to you to call for election of a chair.
Yes, if I can have an election for chair, please, members.
I nominate Stuart Brown.
I support.
Thank you very much, members. So, we'll just wait until we actually get to 10 o'clock, just in case anybody wants to dial in on the live stream. We don't want them to miss any of the proceedings, so just bear with us. We'll wait for the chimes to finish. There we go, it's now 10 o'clock, so we're opening this meeting of the Licensing Subcommittee to determine the application by SBK Southsea.
There's no sound on the live stream.
Okay, quick issue with the live stream that we're going to try and fix.
If someone wants to speak, and then James can check it.
Do we have sound on the live stream now? Testing, testing, 1, 2, 3.
Keep going.
Yes, no, maybe?
It's just coming. I've had this issue before with the sound. If someone wants to say something, oh, hang on, he's coming back.
Hopefully that means there's a yes.
No, nothing.
No, okay.
Okay.
The joys of modern technology, everybody.
Right, James is coming over, so to see if we can sort it out.
Okay, in which case, thanks for coming. Please do bear with us. We will adjourn until James arrives to fix the live stream. We're going to carry on anyway. To start with, I'd like the other members of the panel to introduce themselves. To my right,
I'm Councillor Emily Stradwick. I represent the Hillsey ward.
and to my left.
I'm Yinka Adenirok, Labour Councillor for Charles Dickens Ward.
Thank you very much indeed. So I've got a few bits of housekeeping information to read out first. If the continuous fire alarm sounds, please evacuate the room and public viewing area by the stairwells. Do not attempt to use the lifts. Please assemble by Queen Victoria's statue in Guildhall Square. In order to comply with the Guildhall Trust's fire marshal regulations, anyone who signed in at the Guildhall reception desk should sign out when leaving the building at the end of today's meeting. Please can everyone use the microphones and remember to switch them off when they have finished speaking. So we're going to do introductions around the table. So if we just start on my left.
Good morning, everybody. My name's Ben Attrell. I'm a solicitor employed by the Council, and I'll be advising the subcommittee this morning.
Good morning, everyone. Derek Stone, Principal Licensing Officer.
Good morning, I'm Steve Hudson. I am the owner of the licence for SBK.
John Walsgrove, solicitor for the applicant.
I'm Michael Cross. I'm a local resident. I've lived in Southsea for 50 years.
Hello, Laura Cook, a local resident close to SBK.
Morning, I'm Adrian Bird, local resident close to SBK.
Alison Harper, Democratic Services.
Thank you all very much indeed. Members, do we have any declarations of interest that we need to declare? No, lovely, thank you very much. So, we are here to determine the application for variation of a premises licence for Southsea Brunch Club, 119 Elm Grove, Southsea, to consider an application for the variation pursuant to Section 35 of the Licensing Act 2003. Tick that bit. Mr. Stone, would you like to outline the application and any relevant representations highlighting points relevant to the authority's statement of licensing policy and statutory guidance?
Thank you, members. So, as you've said, the purpose of the hearing is for the committee to consider an application for the variation for premises licence, and it's been referred to the committee for determination following receipt of relevant representations from a number of local residents. The variation application has been submitted on behalf of Elm Grove Enterprises Limited and relates to the premises known as Southsea Brunch Club and is situated at 119 Elm Grove, Southsea. There are no changes to the licensable activities or times of operation, and I'll explain that shortly. So the application follows a premises licence inspection at the premises where it was noted that the premises had changed from what was recorded by the local authority regarding the deposited plan. A small bar had been introduced in the basement area and the available seating area was considerably less than that recorded on the premises licence. An earlier visit by public protection officers following up a noise complaint had recommended the installation of an inner lobby at the front of the premises to prevent the outbreak of noise. The proposed changes to the current authorisation are as follows. The submission of a new plan to incorporate the inner lobby at the front of the premises and a small bar in the basement. There are several proposed changes to some conditions on the existing premises licence as detailed in the application. These include the removal of a police station address that is now closed and doesn't exist, the updating of CCTV conditions, the rewording of a condition to remove alcohol sales only to persons taking table meals to actually read substantial meals shall be available until 90 minutes before the premises close, and to reduce from 110 covers to 70 covers. The applicant has detailed in the operating schedule the steps intended to support and promote the licensing objectives, and these can be found in the redacted application form attached at Appendix A, and the current licence is attached at Appendix B for your reference. A bit of background information. The provisions relating to the variation of a premises licence are contained within Part 3 of the Licensing Act 2003 and associated statutory regulations. Public notice has been given by way of press notice, a premises notice, and local ward councillors were notified of the application. There are no grounds there for the committee to reject the application for non-compliance with the prescribed advertising requirements. So in November 1975, quite a while ago, the premises was granted a justice's licence under the name of Hoagie's, which later changed to Touchdown. A variation to the premises licence was submitted in August 2005 to extend the hours of opening for alcohol sales on Sundays to Thursday until 2 o'clock and on a Friday and Saturday until 4 o'clock in the morning. The police at that time made representations against this application, as did 14 local residents, and on the 29th of September a licensing subcommittee was held to determine the application. During this hearing, the applicant amended their application, and the decision that was taken by the licensing subcommittee on that day is in your committee bundle at Appendix D. The premises have traded under various names. They started off as Hoagie's, you've heard. They went to Bangkok Spice. It became Big Ernie's in 2009, which was an American diner. In 2013, it traded at Jags at 119. Then in 2021, there's Three Cuts Burger and Tap, and it became SBK in 2022. The premises are located on the corner of Elm Grove and St Peter's Grove, close to residential properties, as you've heard. There were no representations received from responsible authorities. The police did ask for a slight amendment to the conditions in relation to the CCTV that was offered by the applicant, and once that had been agreed, the police had no objections to this application. There are 12 representations received from local residents who have raised concerns regarding how the premises are managed and operate, and how noise and antisocial behaviour, which they attribute to the clientele frequenting the venue, have created noise, crime and disorder and antisocial behaviour. And you can see all those attached at Appendix C in your bundle. So when determining the variation application, you must have regard to the promotion of the licensing objectives, which, as you know, are the prevention of crime and disorder, public safety, prevention of public nuisance and the protection of children from harm. The Licensing Act of 2003, the adopted statement of licensing policy, judgments of the High Court, which your legal advisor can give you assistance on should that be necessary, the current statutory guidance issued by the Home Secretary in accordance with Section 182 of the Act, the representations including supporting information presented by all parties, and the human rights of all parties concerned to ensure both a fair and balanced hearing and to consider any public sector equality duty. The Statement of Licensing Policy lays down a general approach to the determination of licensing applications, and any such application will be considered on its individual merit. Equally, any person permitted by the Act to make relevant representations to the committee will have those representations considered on their individual merit. In the report, members, I mentioned paragraphs 47 and 48, which references whether or not incidents can be regarded as being in the vicinity of licensed premises, and at 48, the reference in relation to licensing law is not the primary mechanism for the general control of nuisance and antisocial behaviour by individuals once they are away from the licensed premises. However, it is a key aspect of such control, and licensing law will always be part of the overall approach to the management of the evening and nighttime economy. The updated statutory guidance issued by the Home Secretary in accordance with 182 of the Act refers to the consideration of applications for the grant or variation of the premises, and you may wish to consider paragraph 937, it's in the report. As a matter of practice, licensing authorities should seek to focus the hearing on the steps considered appropriate to promote the particular licensing objective or objectives that are given rise to the specific representations, and avoid straying into undisputed areas. Members, I don't really think I need to say much more other than when determining the application, where relevant representations have been made, and you'll hear from the residents shortly, the licensing authority must hold a hearing to consider them, unless the applicant or each person has made representations and the licensing authority agree that a hearing is unnecessary. And having heard regard to the representations, the committee can take such steps, if any, as it considers appropriate for the promotion of the licensing objectives, which are to modify the conditions of the licence or to reject the whole or part of the application. And for this purpose, the conditions of the licence are modified if any of them is altered or omitted or any new condition is added. In discharging your duty in accordance with the above, the committee may vary a premises licence so that it has effect subject to different conditions in respect of different parts of the premises concerned or different licensable activities. Members, I do have a couple of additional points I do need to cover. On Wednesday, I think it was, I received some video clips from Karen Fricker, who supplied 2 videos of people outside the premises. I did bring a projector today to try and show you, but it's unfortunately up. I can't show that, but I can show you that on my laptop. They have been supplied to Mr. Walsgrove. He has seen them. And in addition to that, you'll see a photograph on your desk. That's a photograph that's been submitted by Pam Newark, and it was taken on the 19th of August at 2036 from outside the laundrette in Elm Grove. who Pam asked for that to be shown today. And lastly, over the weekend, this morning, I came into an email from Mr. Marshfield about a noise issue which he experienced over the weekend, and I've shared that with Mr. Walsgrove and Mr. Hudson, and that is before you as well. It's about the noise collection from the premises. I don't think I need to say any more at this stage. If I can assist you any further, I will. Thank you.
Yeah, sure. Go ahead.
Thank you, Chair. There was an exchange of emails about an email that had been sent with some representations direct to members. Do you know if that has formally been disseminated to members now and the parties, or is that still in abeyance at the moment?
I know it's been shared with Mr. Walsgrove, but I don't know about members.
Okay. It probably would have been better if that had been done. Do we have it available for members to see in some format or another? Yeah. Okay. I trust there's no objection from premises at this stage. Just for information, the residents' spokesperson, Mr. Cross, emailed members direct, and my advice was not to read that representation at that point in time. And this is that document now. It's been clarified that he is representing those that have made relevant representations, so it's quite admissible.
Thank you, Ben, and thank you, Rocky. Members, do we have any questions for the licensing manager? Okay. Councillor Nearing?
Yes, thank you so much for that report. But if I may ask, what are you doing differently to keep the noise, because obviously that is what the residents are complaining about the noise. So do you do something different to keep it low, or what are you doing differently?
That may be a question for the applicant rather than for the licensing manager.
Okay.
Sorry. Just to clarify, any questions on the presentation of the report?
Okay.
Yeah.
Oh, sorry, because it's my first time, obviously.
No problem at all. If it's all right, I've got a couple of questions just to try and get some context to the licensing policy area we're operating in. So how regular or irregular is it for a business to apply for a licence retrospective of changes being made?
Well, it shouldn't really happen. A variation should come in before anything, the changes are made, for the very reason that we would want to inspect and check the premises to make sure that the variation is acceptable and suitable. So it's quite rare.
And does the council have any existing licensing policies around the location of late night venues in the city and what operating hours would constitute being a late night venue?
Now, the only policy in relation to late night venues is the controlled zone around the Guildhall Walk. So it's the area where we restrict the number of premises because of the volume of crime that's been committed in that area over many years. But everywhere else, there is no policy.
Thank you. And one final one. In its current ownership, has the venue, to the best of your knowledge, been complying with the 2005 conditions on the licence? Or have there been any complaints to licensing about breach to those 2005 conditions?
The reason why I visited in the first place was because we were getting complaints around noise, and I know my colleagues in public protection were engaged as a result of at least 2 complaints about noise. They had visited the premises and were talking with the premises in relation to the lobby that we've heard. I did an observation of the premises for a short while, one Saturday lunchtime, and the front door of the premises was open. And obviously, the condition is the door should have been shut. So it's a minor breach, and that's at that point why the business itself made contact with Mr. Walsgrove, and that's how the actual variation has come about.
Thank you. Before we move on, members, any further questions? Yeah, Councillor Strudwick.
Just to clarify, we've not had any deputations made by the police or council responsible. I think you said it, but I just want to clarify.
None of the responsible authorities have made a representation, that's correct.
And then just in the back of the pack, we've got a picture of an LED sign. Can I just confirm that's not a licensable access? We can't judge on an LED sign.
No, it was submitted as part of the representation by that person, and their views you can see are recorded, but I can't enforce that as regard to licensing, no.
And just another one, is there any other places around here that have got a similar alcohol licence? Any other? I've never visited this road, so I don't know much about the street, so I was just seeing if there's any other alcohol licences there.
Yep, there's many in the road. You've got, at the far end of the road, you've got places like the Fat Fox and the One-Eyed Dog. I think the Fat Fox goes to like 4 o'clock in the morning. The One-Eyed Dog goes to possibly 3 off the top of my head. You've got the Deco, that's certainly a late licence. And then the other way, you've got places like the Honest Politician. So there's a lot of licensed premises around the area.
Members, last chance for any questions to the licensing manager? No? Okay. Would the applicant or their representative like to make any questions of the licensing manager?
No, thank you, Chair.
Okay, thank you. And would any of the other representatives? Yes.
You mentioned, Mr Stone, a reduction on the number of covers in your report from 110 to 70. Yeah? Can you confirm that that's not the wording of the application? The application says 70 seats, which are not the same as 70 restaurant covers. 70 stacked chairs in a corner would meet the condition that's being applied for.
That's your interpretation. My interpretation, 70 covers, is people that can sit down and eat meals, but I'm sure Mr Walsgrove would have answered that.
70 covers is not what you said. You said 70 seats, which is different.
The other way around, I think.
I think from reading the application pack, the wording in the application for the variation is 70 seats. Okay. Well, when we get to the applicant's case, we will have an opportunity to ask them whether they intend for it to be general seating or restaurant covers.
To follow on from that, I understand that you or your team have made a number of visits to the premises, and you were asked whether the licensee has been in compliance with the licence at each of those visits. Now, you mentioned some minor discrepancies. When was the licence actually granted? September last year? Would that be right?
Just bear with me.
It's in the information pack on the licence itself.
Well, it was last amended looking at the licence in November 2022. And so I can only presume that was when SPK actually became SPK.
Fine. So we're very nearly a year on. How long would you consider to be a reasonable time for there to be discrepancies while a new licence beds in? Would you think that still having discrepancies after this length of time suggests that the licence...
That's not for the officer to give his opinion on. The licensing authority have not made a representation. Mr Stone's function in these proceedings is to provide the committee with an impartial report on the facts, i.e. what the application is, what the history of that licensed premises is, which he's done. He's not entitled, nor should he be asked, to give his opinion on anything else.
Chair, I think I would just step in to say I would agree with what Mr Walsgrove is saying, but the residents will have the opportunity, of course, to put that question to the applicant in due course.
Obviously, as the licensing officer present, Mr Stone is just here to introduce the report. So if we have any questions about the nature of the report or the contents, that's absolutely fine. When it comes to things outside the report, it will need to go to the applicant.
I accept that. Thank you.
Yeah, hi, thanks. I made, when I made my comments on the application, I mentioned about fire safety. and I was a bit concerned about the fact that the basement had no fire exit and there was going to be more people in there. But you said that the fire department haven't made a representation. Have they seen that concern that I raised?
When an application is submitted, all responsible authorities will have been notified. We don't enforce fire regulations as a licensing authority.
No, I understand that. But obviously everyone works as a team, don't they, on these sort of applications. So
The premises members will be able to comment in relation to what policies and systems they have in place in relation to that.
I suppose the point is I've gone to the bother of making the suggestion or the concern, and that hasn't seemed to have gone anywhere.
I think, Chair, it might be useful, sorry to interject, I don't like to normally jump in quite so much as I am at the moment, but I think it might help the subcommittee understand that since the fire regulatory reform order, fire safety issues are now dealt with by the fire authority and not by the licensing authority, so there's really no discretion about, they have their own powers to take enforcement action and to close a premises if they think it's unsafe ultimately. It is now no longer really a matter for the subcommittee to be focusing its mind.
But to be absolutely clear, the fire authority would have been informed about the application. They would have seen all the same paperwork that we've seen. So if they chose not to make a representation, that is their choice.
It may help, so if I just add that there are many licensed premises with basements that don't have an immediate escape route from the basement. It is safe. Obviously, the capacity of that room is then limited by the travel distance to get up the staircase and out of the fire escape. So the premises has a suitable fire risk assessment that has determined that the basement is a safe space with a restricted capacity with the fire exits that it's got. And obviously, it's been that way for numerous years now. It's not a matter which you need to be troubled with.
So there is a risk assessment, are you saying? Oh, okay. Okay, I hadn't seen that risk assessment.
So this
You're not entitled to see the risk assessment. It's a fire risk assessment that every licensed premises has to carry out themselves, which the fire officer, if they ever had cause to visit, would check and decide whether that was appropriate or not. So
I would invite all parties present, if you have questions relating to the application or the venue, please do wait until after the applicant has submitted their case. That's when we have the opportunity to question them.
Yeah, it was relevant to the fact that the fire department haven't seen or haven't commented, which is what I was quite surprised about. Okay, so I have another question. So there was a recent, and I think it's relevant, I know in your summary, that there was a recent stabbing outside the restaurant. And I don't think that's been mentioned as part of the...
I don't think that's been raised in any letter of representation, so it's not a matter that can be raised now. In any event, that happened when the premises were closed and had nothing to do with SBK.
May I take issue with that? The premises were open at the
You
time.
may not take issue with it because it's not a matter which has been raised previously.
I think, Chair, just to step in once again, I should warn the residents through yourself, Chair, that obviously any new matters, any new issues that haven't been previously raised in written submissions either during the initial consultation period or submitted throughout the course of the proceedings up until today cannot be relied upon. Parties to the hearing can expand upon points that issues that they've already raised in their written representations. They can't introduce new evidence today, unfortunately.
Thank you, Ben. Yes.
I think the point in that regard is that the surprise of the absence of the reference to that from the police, and I think that the police report or the information regarding the police's position was not available to residents when they submitted their concerns. It has arisen from receiving Mr. Stone's report that the police are not reporting to you about what we consider to be significant incidents.
And unfortunately, much like with the fire service, it is down to the police force to choose whether or not they want to make representations, and in this instance they've chosen not to. And I would not like to speak on their behalf, I'm afraid, sorry.
Okay, I do have just another quick question or a statement really. I know you said quite a lot in your introduction there, which was great, thanks. And just looking at your statement of licensing fundamental principles, it says quite a lot in those principles about how the licensing authority will primarily focus on the direct impact on the activities taking place and on members of the public living, working and engaged in the areas. And I think that's quite an important point to make, that's a fundamental principle of the licensing policy. And I know you mentioned about it being an holistic approach to the nighttime economy, but it would be quite nice to put a bit of emphasis on that so that we as a community sort of feel we're a bit more involved in the whole application, because that is mentioned quite a few times throughout your policy document. Thank you.
And that will be something that the panel will take recognition of as you deliberate.
Thank you.
Are there any further questions for the licensing manager on the report? Anyone at all? Going once, going twice. Okay, we will move on. I'd now like to invite the applicant or their representative to present their case.
Thank you, Chair. I know Mr Stone has set out in his report the details of the application. It's finished. But let me just run through them again, because there are numerous parts to the application, and you, obviously, as an experienced committee, know that you can either grant the application as we've applied for, or you can grant it in part. And so you may need to turn your minds to each separate part of this application. So just running through it briefly before I turn to the merits of the application. The principal part of the application is to approve the layout plan, which has changed in two respects. Firstly, to add a lobby to the entrance, which was specifically added working with environmental health to try and address the concerns from local residents about noise escaping from the premises. And obviously having a lobby added does require a variation to the licence to approve a new plan. So that's one part of it. There is also an additional service bar that's been added to the basement. My client added that bar without knowing that there was a requirement to have the plan approved. Effectively, it was added so that the basement area could be served from that small service bar, as opposed to the bar staff and waiting staff on the floor above to be taking drinks down below when, as you've seen from the conditions on the licence, we have 110 covers with 25 people allowed to be at the bar. So the bar area can get busy and therefore waiting staff were finding it difficult to be able to go to the bar, get drinks, then serve the tables both on that level and in the basement. So they added that service bar. And it was on Mr Stone's inspection of the premises when he was dealing with a complaint from a resident about the brunch offer and whether that was actually an irresponsible drinks promotion, that he became aware that that bar did not appear on the plan, and therefore contacted me, as he knew that I acted for these individuals, and said you need to make a variation straight away, which is what we did. At that stage, the opportunity was taken to then look at the conditions on the premises licence. So there is a CCTV condition already on there, and obviously CCTV has been installed at the premises. There's both internal and external digital CCTV. The wording of the condition just needed to be changed, principally to include the provision of CCTV at the request of the local authority. So historically in your city, conditions around CCTV for licensed premises had been worded that only the police could ask for CCTV. And so I know from acting for a number of people in the city that gradually over time that condition does get changed to then add in, you must provide it if the local authority requests it. So on Mr Stone's recommendation, we decided to change that condition, and then the licensing police officer wanted a tweak to that, which we instantly agreed to. So I would hope that changing the plan and the CCTV condition are certainly not contentious matters before you. There's also the condition which mentions the address of the police. It can't be controversial to change that condition because it doesn't make any sense anymore. And then also the condition for the hostess to supervise departure. Again, we've asked for that to be removed. I think that is a condition which in any event is too vague to be enforceable. It's odd that a condition requires a female member of staff to have to supervise departure from what principally is operated as a restaurant. I don't know whether you're familiar with SBK, but it is quite a small premises. It only has one entrance, which is now a lobby entrance. The bar is to the right-hand side, only probably from where I'm sat to the wall there. So waiting staff and bar staff can see the door, in addition to which at weekends there are SIA security at the premises to manage the people, as you've seen from photographs, queuing outside to get into the premises. And so having a condition that a hostess must supervise, I mean, what does that even mean? Does that mean they have to keep an eye on someone leaving? I guess that's what it does. Well, every member of staff can do that because they see people coming in and out of the premises all the time. Why does that need to be a female member of staff? Because that's what a hostess is. Not a host, hostess. So it's just a really old-fashioned, out-of-date condition which should be removed and shouldn't be controversial for 1 minute. I think the issue that you've really got to get your teeth into and what the residents are not happy with are the changes to the conditions regarding the sale of alcohol for people sat down being ancillary to a table meal, and the removal of the condition that only 25 persons can be at the bar. And we'll come on to that in a moment. And obviously the reduction of the number of covers, seats, whatever terminology you decide is more appropriate for that condition. The premises itself is not going to change in its character, whatever decision you make today in terms of those conditions. So its primary focus is on food, its concept of the brunch. What it's trying to achieve is a degree of flexibility within that. So it's still going to operate as a restaurant. But obviously the way people enjoy their evenings out these days has changed quite considerably from when, under the old Act, pre-2005, it actually defined what licensed premises were, whether it was a nightclub, a restaurant, a pub, etc., etc. This new Licensing Act scrapped all definitions and just called it everywhere a licensed premises. So I want to reassure you that the focus is food. It is to trade as a restaurant, but there are limitations and there are some grey areas on the conditions. So, for example, it uses the word ancillary to a table meal. Well, at what point is ancillary? Is that the number of drinks you can have after you've eaten your meal? Is it a period of time after you've eaten your meal? So in terms of enforcement of licensing conditions, which you know must be clear and enforceable, there is, in my respectful submission, some grey area as to what would be ancillary, and therefore if people are sat at tables having had a meal but are still there an hour after they've eaten and still consuming alcohol, who's to say whether that's ancillary and complies with the condition or not? I think the way that we've worded the conditions is much clearer, that substantial food must be available. That's easy to enforce. You can go into the premises and order a meal at the time up to 90 minutes before, because our proposition would be 90 minutes consuming alcohol after a meal is still ancillary to that meal. But what it also allows is the flexibility of people who have finished their meal to not have to sit where they've had their meal and to maybe go to the bar and have a relaxed drink at the bar, then freeing up that table for other people to come in and use and eat. So that's all we're trying to achieve. We've not asked for a change to the hours. We've not asked for a change to any of the licensable activities. We're just saying we want a bit more flexibility in how the people who are coming there to eat enjoy their evening at SBK. We are aware of concerns that have been raised by local residents. Obviously, there has been communication directly with the management of the premises. Mr. Hudson, who is the director of the company that holds the premises licence, wants to reassure everybody here that he stresses that he wants to work with people to ensure solutions are found to issues that they raise. And so, for example, the lobby going onto the front of the door, so that even when the primary door is open, music then can't escape. But it is important to say that everything that happens within the vicinity of those premises is not directly as a result of SBK customers. We accept there are some issues, and there have been some issues, but what we say is they are very few and far between. They are sporadic. A lot of what has been said by residents is general antisocial behaviour in that area, which has no relation to SBK at all. So, for example, the incident that was raised about the stabbing, the premises were closed. The police actually worked with SBK and asked for it to provide CCTV from its external cameras. So the premises were working with the police to help them in their inquiries. It had nothing to do with them, but local residents thought that it did because it happened in close proximity. You have in your pack, I think, some photographs where there is a group of girls behind a camper van and detritus left behind that camper van. Those women were not customers of SBK, and in fact Mr. Hudson was working that evening and provided welfare support to that group because one of them was extremely drunk. They weren't customers of SBK. The detritus that is behind the camper van, none of those products are sold by SBK, and that's just one example of where the residents are so sure that it's to do with this premises, and it absolutely isn't. So we just want you to make sure you strike a fair balance, that we're not saying that there won't ever be a single issue at SBK. They're licensed premises. There are unfortunately people who go to licensed premises who do misbehave, but this management do take a strong view to that and do ensure that the premises are well run, and if there are concerns for local residents to speak to the management directly, as they have been, and they can get responses from the management to say that actually wasn't anything to do with us. So getting a much clearer picture about antisocial behaviour in that area. I think principally the point to support this application is the fact that the police and the Environmental Health Service have not made a representation to you against either the change to the plan or the amendments and removal of the conditions that we've requested. Now, if the residents' assertions had credibility and everything they said had happened and involved SBK customers, you would have expected the police to have made a representation, and they haven't. Likewise, the issues around noise. We know that there has been an investigation regarding complaints because obviously Environmental Health have approached us and we've tried to work through the solutions. But notably, you will have read in one of the representations that advice was given to one of the residents that actually the noise from SBK was not higher than the background noise of the traffic going past the premises, and therefore there wasn't a noise nuisance. So again, had there been nuisance being created by SBK, action would have been taken by your own officers, and they would have made a representation to you today. I think principally because obviously I can't speak on their behalf, but what I'm saying in support of our application is we're not changing the hours, we're not changing the activities. Effectively, we're not changing the capacity of the premises. It's just asking for that bit of flexibility where conditions are much clearer in terms of enforcement. People can go to the restaurant, eat, and then stay a bit longer and enjoy themselves until the end of the evening. And principally, the queues that are outside where you've seen the photographs would and should disappear, because those people are waiting to get into the premises to have a drink. Now, obviously, with the current condition of only having 25 people at the bar, it has to be effectively a one-in, one-out policy of those 25 people at the bar. So that condition does create the issue of having a queue of those people outside. I would say that the queue is, as Mr Hudson would say, managed well, and the issues are not with people in the queue or from people who exit the premises to smoke. And you'll have seen, we haven't seen the video clip yet, but you'll have seen the photographs. Actually, the queuing there is orderly there, and the video clips, should you see them, don't show any nuisance being caused by the people in the queue. They're literally just stood there waiting to get into the premises on this one-in, one-out policy, which, if you decided to grant the application and remove that condition, there would not be that queue of a dozen or so people outside on their busier nights on the Friday and Saturday night. So I commend to you this application on the following basis, much of which is uncontroversial in terms of the changes. With regard to the controversial changes, Environmental Health and the police have not objected. Much of what has been said by the residents has been shown not to be associated with SBK, and accordingly we ask you to grant the licence as applied for, knowing, of course, that the residents can at any time review the premises licence, where the onus does then shift to them to be able to prove what they're saying by credible evidence. But with this underlying theme, Mr Hudson wants to stress again his willingness to speak to the residents, to liaise with them, to address any concerns they've got. He, although had as a director a hands-on role, now has much more engagement with the premises, and in fact, obviously since the level of complaints has risen from this application, because obviously the residents have seen it, that they need to get in as much negative press, shall we say, against the application. He has been working himself at the premises for the last 4 weekends and will continue to do so. They have appointed a new manager to the premises who will be starting this week. And again, so his name's Fabio. Again, the management team at the premises are more than happy to address concerns. So if residents do have issues, the management will always respond to them. But what is important to note is, certainly from my working of this case, a lot of criticism is levelled at the premises unfairly, because anything that happens of antisocial behaviour or nuisance, they just immediately attach it to the premises, which is not fair. So we ask you to grant the application. Obviously, we're happy to answer any of your questions or those that the residents may have.
Thank you very much. Members, do you have any questions for the applicant? Councillor Strudwick.
Just reading this email, it's regarding the bins. Is there a way of you getting the bins emptied later?
Absolutely. It's an issue we've had at another premises, and once it was brought up and we spoke to Viola, they stopped doing it. So they're a professional company. They're a very large company. I mean, I would have thought that they would have not gone at that sort of time, but I guess there's pressures on their drivers, but we will explain to them that that's too early. And again, we'll come up with a reasonable time that they can't do anything before that.
What I must add to that, of course, is in relation to the collection and deliveries, that has no relevance to the actual application because it doesn't tie in with anything that we're asking for. Had we been asking for different hours, etc., then, but it's just an example of it's a concern that's raised, a legitimate concern, which Mr. Hudson is now going to deal with. That's the first he's been aware that it has been a problem for residents.
Okay, so I do have a few questions, I'm afraid, sorry. So obviously, like my colleagues, I'm not familiar with the venue, so I did do a little searching online just to get an idea of what we were looking at. Can you confirm for me, please, what your current opening hours are on each day of the week?
Yeah, so we don't open on Monday to Wednesday. Thursday we're open from 7 p.m. till normally about 11 o'clock, 11:30. It's not a late evening. Friday from 6 p.m. till 1 a.m. and Saturday from midday until 1:30 a.m.
And Sundays?
Sundays from midday to about 7 p.m. We have live singers in.
Okay. But obviously those are not the same hours that you're permitted to be open by the current conditions on the licence.
That's right. The hours on the licence are much longer.
Okay. So, just to get an understanding, what prompted the initial changes at the venue, so the reduction in the number of covers?
The application is, as I said, is to allow that flexibility where someone has come and eaten a meal and then wants to stay on and have a drink at the premises, which I would argue as a lawyer is still ancillary to the meal because the main reason they've gone there is to eat a meal. People's social habits have definitely changed. So I would say a decade ago, someone might go to a restaurant and then might go on somewhere else to either a pub, perhaps, or more generally, before the Licensing Act came in, people would go out either to a pub or to a restaurant and then on to a nightclub. This labelling of licensed premises, as I said, disappeared when the new Act came in because anybody could apply, any type of premises could apply for whatever hours they wanted to run their business for, as long as the licensing objectives were promoted. And that did change people's social habits. So the traditional go to a restaurant, go to a pub, then to a nightclub has gone because, of course, a lot of the licensed premises, the traditional pubs and restaurants, got later hours and tried to encourage customers to remain longer. You've heard there's been a long history here of different owners and different operators, and sadly that's because operating solely as a restaurant where you might get customers coming and eating till sort of 10, 11 o'clock at night, it's very hard work when you're in such a competitive world to make sure you are at 100% occupancy of all your covers to make sure that your business is successful. So what SBK are trying to do in this application is it's still the principal focus is the food, and from a commercial point of view there's more profit selling food than there is alcohol. The margins are much higher on food, so that's still their main focus. But they want to be able to have the flexibility of those people who are coming to them and eating, of being able to stay and have a drink, whilst also accommodating people who just want to come to the venue for the atmosphere and to have a drink, maybe to meet friends who've had a meal there, they're just coming to meet them to have a drink. None of that really works with those current conditions. They're very restrictive. Having 25 people at the bar, and as I said, that does lead to that queue of a dozen people or so outside who again want to come experience the atmosphere of the place. So it's the conditions are looking to give it that flexibility while still giving the primary focus as a restaurant in its old-fashioned term.
I want to stick with the reduction in the number of covers just for a second. So 110 down to 70 is a reduction of 40 covers. That's over a third of the existing covers in the venue. Obviously, if we're looking at the capacity, there's no reason why people who have had a meal at a table and then want to stay on for a drink couldn't stay at the same table and continue drinking. But with the capacity of the venue, the 40 covers leaving, what increase in capacity of the venue do you think those 40 covers would allow for people solely on the wet trade side of things?
Yeah, firstly, you can't get 110 covers in there. It's not a big enough place. So how the person who ever got the licence in the first place managed to convince the council that you could get 110 people seated in there, I don't know.
So how many covers has it been operating with
can't.
as solely a restaurant?
85, and that's principally, yes, you say, all right, well, we've caught you out, we've got you for breach of the licence, but as I said, you couldn't get 110 restaurant covers in there. It wouldn't have been appropriate. And yes, the client could have come back and varied that, but to be honest, they just took the decision that they need to. Nobody had been operating 110 covers all these years. When they bought the premises and went in, there weren't 110 covers there. So they operated what they considered was a safe capacity. What makes it awkward is the 25 people at the bar, because the bar area is 25 people fills that space. There's no more space for any more people than 25, because there's a table at the end. So they're trying to maximise the number of covers, but also provide that bar space. And yes, you're right. In terms of people eating a meal, yes, they could stay at their table and drink, but the current condition requires them to be served at that table by waiting staff. And of course, if they stayed there for a couple of hours, they are taking a cover that could be used for someone who wants to come in and eat food. So it restricts the flipping of the tables, which I'm sure you'll understand commercially. As a restaurant, that's what you want to be able to do. You want the people who are sat down at tables to be eating food as much as possible, not sat at that table just having a drink. Because you might buy one drink, I don't know, say every half an hour to an hour. Well, that's not going to make the restaurant enough money to justify staying open, which I suspect is why so many businesses before SBK at this venue have not succeeded.
Okay. What is your intention for proposed capacities for upstairs and in the basement?
So in the upstairs, that's where we would have about 60 covers, and then down in the basement there would be 10 covers. And then overall, you're looking at no more than 150 as a maximum capacity to be in the venue. But that's not, I'm saying from a safety point of view, that's not the number of people that they would have in there. So at the moment, they're probably working on a capacity of around 80 in terms of the number of people that are in the venue at one time. So that may increase up to about 100, 110 on the busiest night.
Okay. Quick question about the licence, and just wondering why the application wasn't put in before the changes were made.
For the reason I said, so the addition of the basement area is licensed, and so my client just through ignorance didn't realise that just putting in a service bar would require a variation to the licence, because in their minds that bar was licensed, that basement was licensed anyway. Mm-hmm. So they didn't realise adding in a servery required a variation. But obviously, as soon as Mr. Stone pointed that out, they consulted me, and I then obviously had a chat to them about the business and about the conditions on the licence, and to take advantage of having to put in an application to look at changing those. So we yeah, and as Mr. Hudson rightly points out, in terms of the lobby, you know, that was the timing of that came just as the application was about to be submitted, and they took the view that rather than wait for your decision, they would go ahead and install it, because obviously it benefits everybody, and they couldn't see, and certainly I advised them that putting a lobby in was not going to be controversial or opposed by anybody, because it benefits everybody. How can anybody object to something which is a benefit to them? So that was on my advice.
Okay, thank you. Members, do you have any further questions for the applicant? No? Okay, thank you very much indeed. Do any of our members of the public here have questions for the applicant? Yes.
Mr. Walsgrove, you said that the current conditions require table service. Can you point to the condition that requires that for me, please?
Yeah, so the effect of table service is alcohol should not be sold or supplied otherwise than to a person taking table meals there. And obviously, where I've said with the condition allowing 25 people to be at the bar, if people from the table then go to the bar to get the drink themselves, that puts the premises in breach of the 25 at the bar condition. So they have to kind of, and it's difficult because obviously the customers don't know that that condition exists. So when the customers come in and they're having a meal, as you and I probably would, you'd think, oh, I'll just go to the bar and get a drink. So they might get up and move towards the bar, and then the staff have to, if there's 25 people already at the bar, they have to say, no, I'm sorry, you have to go and sit down. I'll have to bring you whatever you want. But in any event, as a restaurant, with you expect table service. So while you're eating and sat at the table, you expect someone to come over and say, what do you want to drink? And go and get the drink. But it's that 25 at the bar condition which stops any movement of the customers around the venue, which is really difficult, and it doesn't really serve any purpose in terms of promoting the licensing objectives.
Well, we seem to have a very strong commitment to abiding by the licensing conditions, which from Mr. Stone's evidence doesn't seem to have been the case. But okay, fine, I take your point. If I can take you to page 65 of the document pack. This is a notification of the decision of the licensing subcommittee of 29th September 2005.
Yeah.
Now, these were conditions that were imposed by the licensing committee following a hearing, and they obviously felt at the time that they were necessary. And looking at them myself, my suggestion would be that they're to deal with issues with the residents. So it's emphasising the fact that it's a restaurant by requiring that intoxicating liquor should not be sold or supplied otherwise than to persons taking table meals, except that it won't be applied to the bar area. When operating, there will always be 110 restaurant covers. Now, are you seriously suggesting to the subcommittee that since 2005, nearly 20 years, it's been impossible for that condition to be supplied, and that the licensing officers on their visits have never, ever in any of that time realised that that condition is not possible to achieve?
I can't speak for the previous operators, because obviously I didn't act for previous operators. All I can say is, in terms of safety, you could not get 110 covers, restaurant covers in that premises. So how they achieved that, I don't know. Whether the fire safety regulations changed, whether they had different risk assessments to allow those capacities to be achieved, I have no idea. It may be that a licensing officer has never visited those premises, because in the past there's never been a complaint. Generally, licensing officers don't make visits to licensed premises per se to check up on licence conditions. They'll only do so if a local resident or one of the police or environmental health have received issues from local residents, which is exactly the case here. Someone had made a complaint about what they perceive to be an irresponsible drinks promotion. So all I can say is it is a small premises. My client would not, with the 25 people at the bar, you can't get 110 restaurant covers in there, and I mean that's the case, but I can't say any more than that.
I don't know how well you know the premises, but I've known the premises from when they were a Norfolk shoe shop, before it even became a restaurant. So I'm very familiar with the premises. The conditions that were attached by the subcommittee were 110 covers and 25 persons. That's a maximum of 135 people in the venue. You seem to be talking about 150 now, was the figure you mentioned. You mentioned you dislike the use of the requirement that females should supervise the departure of customers for the premises. Would you have any objection if it just said staff members instead of hostesses? Obviously, at the time that the subcommittee made their decision, noise from customers leaving the premises must have been an issue, and that's why that condition was put in there. We have no objection to it not being hostesses, so long as there is supervision.
Yeah, I mean, if the committee feel that's appropriate, we're more than happy for it to be changed to staff. As I described, because the premises is very small and only has one entrance and exit, and as you know, is glass fronted at the front. Every member of staff that's working on that floor will see people leaving, and at the weekends there are door security at the entrance there.
But there are blinds on the windows and they can't see out through the windows. The windows are actually quite high off the ground. So, and we are concerned with the behaviour of people in the process of leaving. So that means on the pavement outside as well as inside. We've all seen noisy groups leaving venues.
Yeah.
I'm not saying this particular venue, but we're all familiar with it. People saying good night loudly and everything else. And that's part of, surely, this requirement for supervision is to try and keep that level of noise down.
Yeah, absolutely. And Mr. Hudson is in full agreement that that's what they should be achieving with their staff. And that's one of the principal reasons when they took over the venue, they decided to have SIA door staff employed to manage the customers outside. Now I know some residents think that employing SIA means you've turned into a nightclub, but that just simply isn't the case. Lots of licensed venues employ door security because the law requires anybody controlling entrance to licensed premises to have SIA door staff. You can't have a member of staff stood on the door saying whether someone can come in and to the premises and manage the queue. They have to have a badge, hence the employment of the door staff. My client's more than happy if the committee agree to change the condition so that it says staff, because they are supervised in that way. The door staff do ensure that people outside of the premises behave themselves and leave the premises quietly. And we're not saying 100% of the time people leaving have left quietly. You will know there will always be the exception to the rule, and there will be occasions when people from SBK have shouted. I'm not suggesting for 1 minute that it's never happened. I'm just saying it doesn't happen to the degree to which local people think it does. And yes, we have staff there to deal with that. And if you are happier leaving that condition but rewording it to staff, then so are we.
Fine. Thank you very much. You have mentioned that a new manager, but I take it by that you mean a new DPS
That's right.
is being appointed, so he has not been appointed yet.
Yes, he's been appointed, but the premises doesn't open until Thursday, so that will be effectively his first shift.
Has the application for him to become the DPS been submitted yet?
No, not yet, but it will be obviously before Thursday.
You said in your speech that some of the complaints, or what, no, I don't think you said some, but you said the complaints were shown not to be associated with SPK. Now, this isn't the Old Bailey. We don't have to prove things beyond reasonable doubt. What we're looking at here is, I would suggest, the balance of probabilities. So, is it probable that the residents who have lived there from long before SBK came into being, is it probable that they are making this up and telling fibs? Is it probable that people who've had a skinful, who have not been drinking at SBK, will travel from the premises where they have been drinking to the vicinity of SBK in order to urinate, vomit, indulge in antisocial behaviour as is complained of? I don't think that's terribly probable. I think it is the committee, the subcommittee, have to make up their own minds, and it is not for you to say it's shown not to be associated with SBK. It's for the subcommittee to make their own minds up on that subject.
I agree entirely with that, that the standard of proof is on the balance of probability. Is it more likely than not? Absolutely agree with that comment. I don't agree that I'm not entitled to comment on the credibility and strength of evidence. Of course I am, that's my job. Yeah. And I gave one example where photographs were produced where it was categorically stated they were customers of SBK, and we know they're absolutely not customers of SBK. So I've put that forward to the committee to say, when you're looking at, have the residents on the balance of probability shown this premises to be a problem, do look at the evidence, because we know that evidence has been adduced which has got nothing to do with it. The very fact that you highlight a stabbing which has nothing to do with the premises, it was closed, just supports that argument yet further. So I'm perfectly entitled to put that to the committee. Of course it's for them to make up their minds on hearing from you, on hearing from me, and I agree it's on the balance of probabilities. Is it more likely than not? And we say it isn't more likely than not that these premises are creating such a big issue for local residents. I've said it's not a case that you're not going to get the odd occasion on a weekend where a customer who's been at SBK does not act in an inappropriate way. And it's how the premises then respond to that and deal with that individual. I've put forward to the committee that they can feel confident that the management there is strong enough to deal with those exceptions, which you will get in any licensed premises throughout the city.
Since you've raised the point of the stabbing, it did take place during the permissible opening hours of the premises. I gather the police were called at about 10 o'clock on a Sunday evening to the stabbing.
I don't know how many more times I can say it. The premises were shut. You can't just go by the opening hours on the website or the opening hours on the premises licence.
I'm not suggesting that.
We're saying it's shut, and you can't persist in trying to link it to SBK, because we know for sure it had nothing to do with us.
I'm not trying to, as you say, link it to SBK. I'm just trying to establish whether SBK was open earlier that evening, and if so, at what time it closed.
What relevance has that got?
Well, because it's quite possible, is it not, that people...
I think, as Chair, I'm probably going to have to ask for your permission just to step in for a moment, because I think it was earlier established that the stabbing incident was not formally raised in a written representation and therefore isn't actually evidence forming part of today's hearing. and not actually something that you're going to be able to take into account in any event. So it might be we just save a little bit of time.
Yes, thank you, Ben. And yes, as it wasn't part of any written representation, it's not something we're allowed to consider. So
Okay, fine.
if you wish to have that discussion outside of the hearing, please feel free. But as it's not something we're allowed to consider, we probably should move on.
I think there's one last thing from me. You have mentioned Mr. Hudson's willingness to engage with the local community. So will he undertake to give us contact details for himself and for the new manager? Please?
Yeah.
Thank you.
Yeah, I can do that today.
That's enough from me. Thank you.
Right, thanks. I think that I'd like to sort of just clear the air and say that there's been a restaurant on the corner of St Peter's Grove for many years, and we've never had any issues with it. And I think that certainly from my point of view, having a healthy, vibrant high street is really important for the environment, for the local area. So we haven't got objections per se about there being a facility at the end of the road. It is just the way, obviously, that it's operated, which is causing issues. And I know that it's probabilities and all the rest of it, but whatever, since SBK has been open, there has been marked change in the character and the behaviours around the street. And as far as I can see, there is a causal link between SBK being open and these problems that have now arisen. When it was a restaurant, that wasn't the case. And I think it's quite interesting what you said about there's, definitions in terms of licensing, because I was under the impression that the operating schedule should actually define what the nature of the business is. And that is what the guidance says. And I'm still not clear on whether SBK is actually operating as a restaurant going forward or a nightclub or a bar. I mean, you said yourself that people normally would go to a restaurant and then a bar and a nightclub, but now they're going to stay at SBK and fulfill all of those requirements in one go. So are we a nightclub? Are we a bar? Are we a restaurant? I'm really not clear.
No, it's a restaurant. So its primary function is as a restaurant, and food is the focus. It definitely isn't a nightclub. Yes, it will have music on occasions, but that does not make it a nightclub.
So have you been there on a Saturday night? Because you would not want to eat there on a Saturday night. You cannot hear yourself think. It's not an eating destination. It's not somewhere you would choose to go.
But with respect, that might not be where you and I would want to go and eat on a Saturday night, but people clearly do. So as Mr. Hudson has just whispered in my ear, on Saturday they did 160 covers of food. So that is an exceptional business. It's an atmosphere that people locally obviously enjoy. They have hit upon something which people enjoy. And obviously what they want to do is make sure there is that bit of flexibility to give it longevity and to make it a success, because as you've seen, it's changed so many times, and as I've said, I know that a pure restaurant business is a very difficult business to succeed in nowadays.
So you said that there's bigger margins for the food than there is for the drink.
Yeah.
So why would you want to then change the emphasis to more people at the bar than more people eating? Because surely that would be more sense to keep people eating if there's bigger margins.
Because, as I said, it's about being able to flip the tables, being able to keep the people that have finished eating a bit longer and to spend a bit more money in the premises, and to be able to maximise the operating hours that they've got. So you've heard from Mr. Hudson what the opening hours are. If they didn't have the opportunity to let people, and at the moment it's only 25 people, and obviously they would like that to increase, but if they didn't have that opportunity, obviously just having people come to eat there, come 10:30, 11 o'clock, you're probably closing. So what they would like to do is to be able to have that, as I've said, keep the food available for about an hour and a half before they close. So that would be up to sort of midnight, 11:30, midnight. Beyond that, you're not going to get people coming out to eat a full meal. So that it's just trying to make the business work as best as it can to give it that longevity.
And you said the primary focus was on food. You said that several times. But I think, Steve, you said yourself when we bumped into you on Saturday night that that actually you stopped serving your brunch at 6:30.
Yeah, brunches, but we still do food.
So
So
that
the
isn't...
bottomless brunch, the last seating is 6:30.
Mhm.
We then do full food service afterwards. So you
Right.
can buy food, but you can't buy the bottomless brunch package.
And you, by your reckoning, about 10 o'clock food's all done, 10, 11 o'clock food's all done, and then it just becomes the nightclub after that time.
Not a nightclub. But yeah, from sort of 11:30, 12 o'clock, then yes, it's people who've eaten there, currently people who've eaten there, who stay on and have a drink. And then you've got, as I say, the question, I would say it's ancillary because they've eaten there, they're only staying there for another hour or so. But equally, someone could argue, well, that's taking ancillary and stretching it too far, etc., etc.
Yeah, I would, yeah.
Simply because we had to change the plan and get approval for that, I advised the client in terms of the business that they're running, let's have a look at the conditions and see if we can improve it to make sure that you don't fall foul of any issues, bearing in mind we had been made aware by Mr. Stone that he'd had the complaints about whether the bottomless brunch, for example, was an irresponsible drinks promotion. So it was trying to make sure the client can operate a successful business and in compliance with licensing conditions.
And I think it's good that the business is a success. That's fine, as long as it doesn't have such a big impact on the local community. And then I go back to what you said about being a responsible licensor and all of that. But there's no, from what I could see from the variation order, there's no clear examples of how you're going to deal with the antisocial behaviour that you accept happens in those sort of environments, albeit temporarily, but there is nothing to say this is how we're going to deal with this issue. And I thought that you would have to have said that in your objectives as to how you're going to deal with the 4 licensing objectives, and all I saw was something about underage drinking and some other minor things about CCTV. But there was nothing about how you're going to deal with those issues that have been generated by people drinking after their meal at 11 o'clock at night until 1:30 in the morning, as to how you're going to prevent that crime and disorder and that nuisance. And I would like to have had some reassurance about that, about the positive measures you're taking to ensure that doesn't happen. And I haven't seen any of that.
Yeah, so in a licensing application, essentially whatever you put or write down is transposed into a condition on the premises licence, and so you have to strike a balance when you're preparing any licensing application to know what you should include in your operating schedule. What you don't do is write War and Peace and put in all your operating policies and procedures about how you run that premises, because that would then become a condition on the premises licence. And then any time you wanted to change the way you manage those premises, you'd end up coming back for a variation. So as a licence holder, what you tend to do is put in the key facets of managing a responsible licensed premises, which is to have the CCTV condition, a challenge policy, training for staff. Generally, there's I hate to say this, but there is a kind of standard set of conditions that you'll find throughout the city on the licensed premises, all of which are on this particular licence. And then other premises may have other conditions added should the need require. So we could have, for example, put in our operating schedule, because we do it, that we have SIA registered people at the door at the weekends. Now, we don't see that there needs to be a condition on the premises licence for that to be the case, because we are operating in that way. It's our choice to do so. In fact, we have been criticised by residents for having SIA registered door staff on the door, which I found really odd. But that's the case. So there are lots of things we do that we wouldn't necessarily put into a licensing application. That doesn't make us a bad licensed operator. It just means that's effectively the standard sort of approach. I just wanted to go back on your point about, you know, SBK, it's suddenly them that's caused all the issues. All of the licensed premises around you that Mr. Stone mentioned have all had later hours variations to their licences fairly recently. I know because I've been involved in at least 2 of them. So there has been a bit of a change locally.
So there's some sort of cumulative effect, you think? of all
And
of
there
these
is,
licences?
I'm not saying that, I'm just saying you've singled out SBK and that's what residents have done. We know from some of the examples you've given us, we know that they've not been in our premises, so they must have come from somewhere else. Whether that's another licensed premises, whether it's been a private party, for example, those women in that photo that we've said definitely they weren't anything to do with us. And Elm Grove and St Peter's Grove, they are busy with footfall from people walking along.
But you, no, we've never had it in St Peter's Grove before. But I think you're saying we're singling you out. But you made an application for variation, and we've commented on that. And as part of that comment, we've identified issues that have been happening in the area as a consequence of that. And if this variation is allowed, which in principle relaxes those requirements, because I know you're saying the licensing hours themselves aren't changed, etc., but actually the type of activity that happens there has changed already and will continue to change by your own admission. It will become a drinking place after 11 o'clock. Then actually we are in position to mention that. And that's not singling out, that's just drawing attention to you and you as a licence holder that actually it's already bad and you're going to make it worse. So that's why we're identifying these issues. Whether that's a cumulative effect of the rest of the street or not, the point is that in our street and our areas, things have got worse since SBK has been opened. And that's not singling you out, that's stating a fact.
Yeah, well, the facts that have been stated in the representations are specific incidents saying these are SBK customers. We have shown, I would say, to the correct standard of proof, that they've got nothing to do with SBK. And the committee will have to make a decision, well, on that basis, on the basis that the premises aren't going to change their hours, their activities, the capacity of the premises in terms of the number of people coming and going isn't going to change. The one thing that the alteration to the conditions should do is remove any queuing outside. What impact does that have on the licensing objectives? And the residents have put forward to say, well, it's going to have a really negative effect because all of this is happening already. And we're saying, well, all of that isn't happening already from SBK customers, and we are managing that premise as well.
I don't know how to say it so you understand. Since SBK has been open, the amount of crime and disorder and the amount of nuisance in the street has increased. It's a bottom line. That is it. That is what's happened.
Yeah,
since SBK has
your,
opened.
Yeah, that's your case. It's not my case. We're obviously saying 2 different things, and that's why the committee are here to decide what's the right thing to do.
There was just a couple of other things.
We'll never agree.
No,
You'll never agree with me. So.
Okay, but I would like to see some more demonstrations of how you're going to meet the licensing objectives in your application. So that's probably a point I'd like to
Can
make.
I just reflect back? I know it's not appropriate for me to ask you a question, but what do you think, in terms of a condition then, would be appropriate?
What you're asking me? I mean, I'm obviously not a licensing person.
I'm just
but
wondering
for example,
what you would have expected to
So,
have
for
seen.
example, I would have expected perhaps some CTV covering the corner of St Peter's Grove, so that you can see the people that are coming out of the club and urinating in the street. You haven't got it down St Peter's Grove. No, I haven't seen it. Have you seen it?
Down St Peter's Grove.
Down St Peter's Grove? No, I don't think so.
So on the outside, I mean, obviously it doesn't go
Elm
a long way down.
The Elm Grove cameras point towards the door, I believe. The other thing I would like to have seen is that lobby extended, so that actually when people are leaving, not both doors are open at the same time, because as soon as both those doors are open, the noise The loud noise that comes out of there is deafening. It is really, really loud because both doors are open, so it's useless. So I'd like to see that where it was one door. I would like to have your people showing people off the premises. Maybe they could wait inside for a taxi rather than the taxis coming down St Peter's Grove to pick up passengers. Maybe you could ask people that are screaming and shouting in the road to leave quietly. Are there signs up to ask people to leave quietly? I haven't seen, well, I don't know, I haven't been to the premises, but, you know, maybe asking people to leave quietly. What else?
I think what I'd like to see, we saw each other the other day, and I'm grateful for that meeting. But I think that what would be really useful would to have more of a roving presence, as I think you probably are beginning to do, because having door staff seeing people off your premises has got the tendency to cast them away, but it doesn't manage them within the immediate area. So what people are doing is going round the corner into St Peter's Grove and then using the local driveways or alleyways or gateways or even the side of SBK itself, I saw the other day, as a urinal. In fact, people were laughing at me for treading in it. So it's moving or preventing that antisocial behaviour in a more proactive way, stopping people from having sex around the back of the funeral parlour, stopping people from using cocaine in the car park of Co-op. All of these things have been seen, and all of these things are directly to do with people that are leaving SBK. So to have a more roving presence might alert SBK to our reality that it is a problem that's created by SBK, and also give SBK the opportunity to directly address those problems and prevent them.
And to log them.
And of course to log them, because the logging of these incidents is something that we're going to need to become much smarter regarding as a resident group, and to engage with SBK would obviously be a really useful thing to be able to do.
Yeah. So trying to pick up on some of those points. Last one first in terms of an incident book. There is an incident book which records all incidents, so all complaints made. So if a resident gets in touch with SBK, that will be noted down there. The CCTV does go along St Peter's Grove to the extent of the whole of the side of SBK. So Mr Hudson has just called up the image on his camera, so he can see CCTV through his mobile phone. Yes, we can ensure that staff, as you say, do a roving check around the corner. What we can't do is intervene in antisocial behaviour of people who haven't been to SBK. Now, I know there have been allegations of people taking drugs outside the premises, and my client is aware that not just at this location but elsewhere on Elm Grove there are issues with people taking drugs. What they can't do is obviously intervene where it's not a customer of theirs and their staff can't put themselves at risk to try and tackle antisocial behaviour. But what they can do is give you an assurance that if they see that happening, and if you see it, you report it to SBK, they can obviously report that issue to the police. They can monitor from a distance, perhaps, until the police arrive. I'm sure you can appreciate that they can't effectively police the vicinity of the premises. They can police their customers within the vicinity of the premises. They can't police the general public, but they can work with you to try and tackle some of those issues.
I thank you for that, and I think that the presence of a roving member of security staff would, or Steve, would make a huge difference to what people feel they can get away with.
Yeah.
I think that we're all wary about intervening and the consequences that can come from that, but actually deterrence has got a huge impact.
Absolutely.
Yeah, couldn't agree more. And yeah, we can do that. And so obviously you guys as local residents definitely don't want to be speaking to the individuals that are committing any antisocial behaviour. So, as we've already agreed to let you have Steve's contact details and Fabio, the new managers, you can report the issue into SBK, who can immediately then check, you know, have they left our premises? They'll know whether it's anybody from SBK, and the door team can then deal with it in the appropriate way, which is either to support your report to the police that it needs to be dealt with, because if there is a continual problem, particularly of drug taking, then the premises itself doesn't want that to be happening within the vicinity. That's going to damage its business, because who wants to go to a premises where it's known that people are down the road taking cocaine? So we commit to support you in that way. We've got the same goals as you. We want this to be a successful business that isn't associated in any way with the type of behaviour that you're describing, and I'm not sure there's anything more I can say on the points you made. But
So on the other meeting the objectives, on the nuisance, on the avoidance of nuisance, would you consider reducing your opening hours? Because obviously most of the nuisance occurs at 1:30 in the morning when people are leaving the venue, which is a time when everybody, any residents nearby are sleeping. So that would help if you reduced it to, say, 12 o'clock, which is maybe more of a reasonable hour, as well as changing the lobby. That would help matters quite considerably, I think, in the local area, and would show a real commitment to helping the residents.
yeah, unfortunately, we couldn't agree to reduce the operating hours.
No, but that would really help us, I think.
I mean, Steve will take that comment on board, but obviously he's running a business.
Yeah.
He needs to be able to make enough money to give it that longevity of being able to survive. And as I said to you before, if the hours get cut back to 11, 12 o'clock, you'll see people leaving the premises earlier than that. So they might then only be effectively trading until 9, 10 o'clock, which then will be the death.
Well, and I know you mentioned a relaxed drink at the bar for customers, so maybe the music could be turned down later, so it may be some nice mood music or something like that.
I think it's worth pointing out there is an existing condition on the licence that there shall be no more amplified music after midnight. I think that was one that was put in 2005.
Oh, was it? I know that's definitely happening. Without a doubt, there's music playing until the early hours of the morning.
Live music, I think, is the wording.
Yeah.
Not amplified music.
Yeah, recorded music is permitted later.
Chair, I think it's probably worth me just interjecting, just to give you a little bit of advice about what you are determining today. Unfortunately, you're not able to consider the hours and reduce hours. That's not something that's been applied for, so it's not within the scope of what you're determining.
So I was asked a question, though.
Yes,
wasn't
no, I
Yeah,
appreciate
no,
that, but I'm just
that's
making
fine.
it clear for everybody that's here. So
Yeah, that's
what
fine.
the parameters of the subcommittee are.
Okay, so I think there was just one last thing I wanted to... Yeah, I'm going to go back to now that fire regulation, because you've mentioned it, so I think I'm allowed to do that now. So before, you said that there was a risk assessment done, and so that a risk assessment would have been done for the 110 covers plus the 25 people at the bar, but now you're upping that number to potentially 150. So has that fire risk assessment been redone and resubmitted to the fire authority as a consequence of perhaps being 50 people at the bar in the basement now rather than 20?
No, so the fire risk assessment is undertaken by an expert consultant. As I've said, it's not for the public domain, it's for every commercial operator to get their own fire risk assessment. And that risk assessment will assess capacities based on numerous factors: the width of exits, the number of exits, the number of tables and chairs, the number of people standing. So I can tell you, I haven't got it in front of me, but I can remember the risk assessment. If there were no tables and chairs, the capacity of the venue, so if it was just a standing only environment, it would be 200 people, and then obviously the more tables and chairs you put into the restaurant, the lesser number of people the capacity reduces it down. And as I've said, in terms of having 70 covers available, then we would expect the maximum capacity to be 150 people, but we don't expect to have 150 people necessarily in the venue.
But as you said, the risk assessment will take into account a lot of different factors, and now you have a bar in the basement, so you have less tables, more people, one escape route. Surely that risk assessment needs to be updated in line with...
Two escape routes out of the basement.
Is there?
You know,
There's one into a store. That wasn't on your plan.
There's 2 stairs. There's 2 sets of stairs.
The fire risk assessment,
Didn't see that on your
which,
plan.
which I have to say has got, we're again going into things which aren't even relevant for the committee to determine, because the fire risk assessment is a matter for the licence holder, and the fire authority have seen the plan and they haven't objected. And as I've said to you a number of times, I represent a lot of clients with basement venues that there is no direct means of escape from their basement. It is all just about capacity. And I've tried to explain to you how we intend to operate safely, but from a business point of view, we know the capacity of the venue is not going to, you know, the number of people coming to us and being on the premises at any one time is still not going to be any greater than the 135 that we're permitted effectively by the conditions.
Yeah, wouldn't want you to feel absolutely awful if people burnt to death in your building because you crammed all these people in and then they couldn't get out. Okay.
But so the law requires us to do a risk assessment which sets out a capacity, which you're right, if we breach, then we're liable.
Yeah.
Well, nobody's going to breach their fire risk assessment that a fire consultant's done. I mean, the whole point of moving it away from the fire authority was a cost-saving exercise for the fire service, not having to inspect thousands upon thousands of licensed premises. The responsibility in law is on the licence holder. We've done the fire risk assessment, we've redesigned the premises, we've had the fire risk assessment amended.
Oh, okay. Sorry, that was the question I was asking, whether you had it amended.
Well,
so you have. That's
well, yeah,
fine.
because
Yeah, no,
we
that's
have
fine.
to, it's the law.
Yeah, lovely. Okay. And so just one last thing, and I will be quiet. It was about you being responsible licensor, and I know that you've said that, and that's great that Steve's taken over and all of that, but obviously there's already been evidence that you've breached the conditions of your existing licence. So how can we be sure that in the future, with these relaxed provisions, that they're not going to get more and more breached as time goes on and your limit on the maximum number of people exceeds and the doors are left open and all of that? How do we know that's not going to happen in the future with these new conditions?
Yeah, so in terms of the breach, that was the smaller number of covers, which we say was a positive thing to ensure...
Sorry, I was referring to the 25 people at the bar, which on your Instagram page you show people dancing at the bar, which is far and exceeded 25 people at the bar.
Yeah, I can't comment on that. That's something you've introduced, which I wasn't aware of in terms of the representations made. So I can't comment on that if there has been a breach of that condition. Obviously, what we are putting forward is that conditions on premises licence, yes, they have to be complied with. We accept that in the past there haven't been that 110 covers for what we say is a positive reason. We accept the condition of the door being opened when Mr. Stone visited, and that's as far as I can take it. In terms of conditions on licences, if there is a breach of a condition on a licence, it is a criminal offence. My client is aware of the consequence of breaching it. It can either lead to prosecution or a review of the premises licence where those breaches can be drawn to the attention of the committee. What more can I say? Mr. Hudson knows he has to comply with licence conditions. Whatever determination that the committee make today, he knows he's got to comply with the conditions. Subject to, in terms of breach of a condition, there is always what they call a due diligence defence, where there might be extenuating circumstances where a condition for a very good reason needs to be breached. I'd better just caveat that before saying every single breach is 100% a criminal offence that can lead to a review. I can't really say more than that. I mean, it feels as though we're in a review hearing, which we're not. We're here as an applicant applying for a variation, and it feels as though we're being accused of lots of things that, you know.
Yeah, and I do appreciate that, but our concerns are, as I said before, that already within the licensing that you've got, we've already got problems, so any relaxation of that is going to just exacerbate
you
those
say
problems.
You've got problems, and you know, we're back to this. I'm not going to agree with you. You're not going to agree with me.
Yeah,
so.
but you can't just say it then and just leave it at that, because this is the situation, isn't it? The situation is we're trying to explain to you why we need proper objectives being met, and why we need to make sure that everybody is aware of all the issues that are happening in the area. To just fob it all off as to say that it's, you know, it's not relevant. It is relevant. It is relevant to this particular variation.
Well, I'm not fobbing everything off. The things which are irrelevant, that I've said are irrelevant, and the committee have been advised by their lawyer that they're irrelevant, so you can't criticise me for saying those things are irrelevant. The other things, I'm not fobbing them off. I'm saying there have been things said about SBK which aren't true, which we have, in my view, shown not to be true, but that's a matter for the committee, because that's the information that's put before them, the evidence put before them. They have to test the credibility of that, and as Mr. Hudson's representative, I've put forward an explanation. You know, those girls in those photographs, clearly nothing to do with us, and we've managed that situation well. Mr. Hudson himself is working that night and comes to their assistance. So we're saying we don't agree with you that there have been all these problems. What we're saying is, yes, there will be occasionally a problem, and we will work to resolve those satisfactorily. So it's about having confidence in the good management of the premises, and I accept the residents don't have that confidence at the moment, which Mr. Hudson wants to be able to give you and give you that assurance. He's going to be more involved on a day-to-day management basis. We've got a new manager coming in who is aware of these proceedings, is aware of the concerns of the residents, and the two of you, the residents and the management, need to work closely together, and hopefully you will eventually come round to our way of thinking that it is a successful business in this area and is not having the negative impact on, you know, residents' lives, which you say currently it does. We say it doesn't. That's for the committee to decide.
We've been round this issue quite a lot now. What I'm going to do is ask for a 5-minute break so that if anyone needs to use the facilities, they can. We will return to other person's questions to the licensee when we come back. So that section is not finished, but I'm very well aware that at least one member of the panel requires a comfort break. So 5 minutes, if we can all be back here at 10:02. Thank you.
If I can just ask...
If you do see any members of the panel in the corridor, please do not talk to us.